Perry.
Good morning, Your Honors. Chief Justice Marshall, may it please the Court. I am Daniel Perry. I'm here to represent the plaintiffs. The issue in this case, Your Honors, is how much proof should this court or court below require before imposing an implied easement on lots that have been designated for community use on a subdivision plan. In deciding this question, the court, as it did in the case of the Attorney General versus Abbott 115 years ago, is acting as a finder of fact, because this dispute was submitted as a case stated to the land court. The court is free to substitute its judgment for that of the appeals court and the land court, and it's unconstrained by their purported findings of fact. This case, like the Abbott case, involved a subdivision of land in Martha's Vineyard, which was marketed in the 1870s in the community now known as Oak Bluffs. It was adjacent to the Methodist religious campground that was developed in the 19th century. As in the Abbott case, this plan created a new community, marketed to summer vacationers, and the developer utilized that plan in its advertising. As in Abbott, the plan showed many small rectangular building lots and larger irregular parcels set aside for community use that were labeled parks or, in one case, plaza. And as in Abbott, the developer did not record any specific written statement of the easements that were at issue in connection with the scheme. The appeals court and the land court both determined that the factual similarities between this case and Abbott and the later cases of Carroll and Hinchley and Bacon versus Onset Grove were not as important as the distinctions. In so determining, the appeals court cited the familiar rule that in these cases every case stands and must be decided on its own facts, but it imposed what I believe is a standard that's without precedent in your decisions, and that is that there be clear evidence that the developer made implied or express representations to prospective purchasers in respect to the establishment of parks. The court noted that in contrast to Abbott, there was no specific reference to parks in the advertisement that we found in the 19th century for this plan. And they also noted that there was no specific testimony of actual statements by the developer to prospective purchases regarding the parks.
What's so surprising that the court should require clear evidence that a grantor intends to grant an easement? What's so surprising about that?
Well, Your Honor, the requirement that there be clear evidence of representations made rather than relying on the entire circumstances, I think, is surprising, and is contrary to what I think the court did in Abbott.
The court here didn't say that circumstantial evidence wasn't sufficient, did it? It just said the circumstantial evidence submitted wasn't sufficient.
There was clear evidence that the developer made implied or expressed representations to prospective purchasers in respect to the establishment of parks. Of course, I would certainly argue, Justice Corday, that there is such evidence in this record. But I think that the way the appeals court put it is a little bit myopic, and the distinctions that it points to in between this case and Abbott are really trivial.
Well, look, one of the problems is that in Abbott, it was, within years after the subdivision, so you could actually go out and find some buyers.
That's correct. It was only about 15 years afterwards, I believe, and we're 130. But what I think the court did in Abbott was to ask, what expectations did putting this label parks on a plan reasonably communicate to purchasers?
But if you buy, if all your deed is references, your purchase of land as described on a plan, you don't get everything described on the plan. You just get the land as described on the plan.
That's right, Your Honor. But certainly the plan describes the package of benefits that you're buying into.
And why shouldn't that be in the deed? I mean, describes a package of what you think maybe the benefits are without some affirmative representation that they are indeed included?
Well, it certainly wasn't the case in Abbott that there was any description of the deed. Nothing was said in the deed.
The whole advertising campaign did refer to parks and, buy this, you'll have parks.
I have to point, my brother pointed out to me this morning that actually each of the standard form deeds, which are reproduced in the record, does refer to a setback from parks, which is greater than, and avenues, which is greater than the immediately, than a setback from immediate lots. So it did suggest that the parks was part of the entire presentation.
Mr. Perry, can I ask you this? You know, unfortunately, the plot plan that I have here is quite small, but I take it that when one is buying into a subdivision, some people might have wanted to buy, you know, the little lot, these are tiny little lots, right across from the Court Plaza, or somebody else might have wanted to be right next to what was then Crystal Lake. And do we have any evidence of whether there was a differential in the prices that was being charged?
The one important differential, Your Honor, is that when the parks were sold out of bankruptcy in a deed that included it with the avenues,
$5.
they were sold for $5,
Right.
and the individual parcels were varied from $300 and later I think they were about $150 each. That's what the record shows.
Could I just say, the $5 was for all four?
All 4 parks plus the avenues.
Plus the avenues?
That's correct.
Okay. One other question on that. At the time that occurred, obviously I understand this transaction was done by the trustee in bankruptcy, but was Mr. Luce still alive?
I believe he was dead, Your Honor.
He was dead. Okay.
And the purchaser was, I believe, a relative of his, but the record didn't define that any further.
Okay.
Mr. Perry, the avenues, Webster Avenue and Kidlon Avenue, was there any easement given to these little parcels of land?
No, Your Honor.
So presumably somebody could come along now and say, well, actually what I want to do is I have 2 little pieces on either side of Kensington Avenue, and what I want to do is just build in the between, and there's nothing here that says I can't build?
There's the doctrine of the implied easement that comes from bounding on a way on a plan would prevent you from building, Your Honor.
Okay.
And this court has developed extensive case law on how and under what circumstances that applies, but certainly applies in this case.
Have the streets ever been turned over to the town?
I don't know the answer to that, Your Honor. I believe so, but I'm not sure. The town council may be able to answer that.
Were the parks numbered? Did they bear a number as the house lots?
No, they just have the words Plaza, Webster Park, and Prospect Park. As I said, I think if you look back at what the court did in Abbott, and all your other cases are consistent with it, they asked about the expectations of the parties. And there, again, although there were statements about, although they did find evidence of specific statements, they also made some observations about what expectations would flow from any scheme of the sort. And what the court said is that the expectation that the developer would make these designated parcels open parks free to the public forever was so extremely natural and probable, and any other course would be so unlikely, that evidence of a contrary intention on the part of any one of them would be received with some distrust. If the corporation had announced at the time of making the sales that reserved the right to cut up the open spaces into building lots to sell them after the village should be established, it would no doubt have diminished the sales. If the corporation had intention to reserve this right, the course pursuit of inviting purchasers was inconsistent with common honesty.
Isn't it wildly speculative as applied to this case, as opposed to one where the parks were advertised as one of the amenities that you would be purchasing by purchasing in the development?
Well, Your Honor, they used the plan to sell the lots. The question I have to ask is, and I think Abbott asked, what else could they possibly intended? Why in the world would they put that designation parks on there except to communicate that these were going to be permanent spaces available for public use?
The one says plaza. What if it just said vacant lot or open land?
Well, if it said vacant lot, and this might be a very different case.
Left vacant, right.
But if they're calling for larger setbacks from the parks, and in the context where you have 9 communities, all of which create open space with only the designation park or like words on a plan, I think you have a scheme that is consistent with the understanding that these spaces would be made available.
So is your argument that the court applied the wrong standard, or in applying the standard it reached the wrong result?
Well, both. I think the facts of this case scream out for the finding, which this court is free to make, that there was an intention at the time the plan was recorded that these lots be dedicated to open space. And
intention on whose part?
On the part of the developer.
Right.
And the more important issue, Your Honor, I think, is what the recording of the plan, marketing of it, reasonably communicated to purchasers.
One of the things that is communicated was every building lot was generally 50 by 100 feet. I take it that the 3 open spaces, park, whatever they're called, plaza, are not 50 by 100 feet.
No, Your Honor, they're about half acre to acre in area.
we don't have to decide in this case whether the parks were dedicated to public use, do we? Is there another case pending involving that issue?
I'm not sure, Your Honor. I can say that dedication to public use was the issue in Abbott. We are simply arguing implied easement for the benefit of the residents of the subdivision, and that was the same issue in Carroll, for example.
Now, as I understand it, in 1994, the town all of a sudden decided to assess property taxes.
That's correct, Your Honor.
All right, and they assessed them, I assume, on the basis that these lands could be developed.
That's correct, Your Honor, which is the only reason they would be accessible. I mean, if they were common areas available for public use, I think the practice of towns following guidelines of the Department of Revenue is that they're not accessible.
I'm sorry. So if these were dedicated for public use, they wouldn't be assessed.
They wouldn't be assessed, and they weren't for more than 100 years.
Okay, but the town decided that that was a mistake, and they needed to start assessing them.
I would characterize it as an overzealous assessor, but and I certainly think that everything else in the record, including all the recorded plans, the assessor's plans, all the nearby plans carried the designation that were on the original plan, such as Prospect Park and Webster Park.
Now, these lands, I mean, these are not, and maybe I'm wrong, I got the sense that these are not developed with common areas, picnic tables,
no, they're
all
not,
left rough.
No, you're wrong. And the appeals court thought that was important. And I'd like to point to certain language in Abbott that addressed that issue, because that was the same case in Abbott. The court said the fact that not much was done to adorn these spaces is not of much weight in opposition to the conclusion to which we've come.
So the court was basically saying there was no evidence of open and common use.
No,
It said there was no evidence of improvement.
Yeah, because
But didn't it also say there was no evidence of open and common use, or insufficient evidence? Maybe I misread that.
No, and if I can finish that, what they said is the chief element of a public park in such a place is to have the land kept open. If in a seaside summer resort no improvements at all are made, there will be some benefit from having space left over for air and for an open, unobstructed prospect. Your Honor, I think that unobstructed open space is itself a valuable community resource, has to be beyond dispute in 2006. Is it really the law that one has to put swing sets and a picnic table on a park parcel to preserve its protected status?
Well, this has supposedly been a public park for 130 years.
That's
nothing has ever been done to it.
It's been used by residents of the subdivision for continuously, the record would show, for picnicking, passive recreational use. I think there's some evidence of baseball. There's no physical improvements.
walking, birding.
Correct.
Thank you, Mr. Perry.
I see that my time's over, and I'm going to...
Can I just ask, I'm sorry, maybe I'm misreading this. The evidence of use before us falls far short of showing open and continuous neighborhood use.
Well, Your Honor,
with this easement of, am I wrong? Did the court not find that?
Well, the court may have found it, but I would suggest, well, there's several things involved with that. First, the party stipulated that there was disputed evidence about how much they were used recently. And so the parties took that issue out of the case, and they both said, we agree that it's disputed and it's really not relevant to determine what's going on here. I think the land court went ahead and made findings on that. The second thing I'll point out to you,
all right, go ahead.
Second thing I'll point out to you, Your Honor, is that to the extent the court found that, I don't think it's justified by the record, and you are free to disregard it. And I would urge you to review the record yourself and determine whether that finding was really had a legitimate basis in the record, and make your own finding on that fact.
Thank you.
Thank you, Mr. Perry. Mr. Rappaport?
Good morning, Your Honors. Ronald Rappaport, Town Council. In response to Justice Venus' question, there is no claim here of public right, public easement. The town, there are over 100 parks in the town established in the record, and the town simply wants to make sure that whatever is done here is done by the proper legal standard.
And what's different about this development? I mean, you've got all these other parks. How did you get them, and were they dedicated to you?
No, they were never dedicated to the town. The town's making no claim of public right. We believe that the neighborhood has an equitable easement over these properties.
Okay, I'm talking about all the other 100 parks you mentioned in your town. Are they all different than this in some respect?
They are all over the town. There's all patterned between 1830 and 1870, by which subdivisions were created with parks, and there's a whole I wouldn't say it's a consistent plan, but there are parks throughout the town, and it started as a campground meeting association.
Okay, but these parks are not owned publicly?
They are not. They're not owned publicly, and there's no public easement.
Could I ask you to clarify this issue of that there was a different setback requirement referenced in certain deeds? And where in the record would we find
Okay,
that?
that would appear on A255 through 259. And I'd just briefly like to walk through why I think the court was wrong below. The 1872 plan clearly shows 3 parks which are substantially different in size than the lots. All the lots are 50 by 100. The ad says 50 by 100. The deed into Mr. Reagan, the plaintiff here, at A63 to 64 mentions lots and then appurtenances. What are appurtenances other than roads and presumably parks? The Form deeds, A255 through 259, has different setback from avenues and parks, 15 feet versus lots, which is 5 feet. The deed from the bankruptcy trustee, who has a fiduciary statutory obligation to get as much money as possible. I would just ask you to look at that. That's on page A73. There is no mention of lot. It doesn't describe, when he's deeding out, he deeds out parks and avenues without describing it as a lot or a parcel, but simply saying real estate, and then says all other lots having been conveyed out. The record shows, although it's very sparse, on A85 and A264 through 65, these were never assessed, or no taxes were paid until 1994 when the town began assessing. And the assessment, they should have been assessed subject to a private easement we now recognize, but they were assessed because they're private property and they should have been assessed. No taxes have been paid since, as far as we can tell, 1872. The land court did make a reference that there was a taking, but I think the land court was wrong because the taking was to other lots in the subdivision. That's at A69. So what
they should have been, I'm sorry, they should have been assessed as what?
As private. These are private. There's no public benefit, so they're private property, and they should be assessed. Whether there's a private easement, would lead to a different assessment result, but they should have been assessed. So just in conclusion, I know I only have 3 minutes. Who benefits and who loses? The neighborhood benefits, the public benefits. The town stands to lose several $100,000 if the court finds the other way, but we think that open space is a merit unto itself. The plaintiffs, what do they lose? Their predecessors paid $5 for 4 lots and all the avenues back in 1880. And other than that, have paid no taxes, have done nothing, and it would be a windfall for them if they get these as billable lots.
Of course, they have to pay taxes. $200,000 is outstanding, correct?
$200,000 is outstanding.
They'd have to pay them to use the
Oh,
lot.
yes, yes. I mean, what I'm saying is if this court were to rule in favor of the neighbors, I mean, they'd be charged with an equitable easement, so they essentially would be unbillable.
Thank you, Mr.
Thank you.
Rappaport. Mr. Kimmel?
Good morning. May it please the court. My name is Ken Kimmel, and I represent the individual defendants. I'd like to make 3 points this morning. First, that the law always has been and should continue to be that the mere reference to parks or open space designation on a plan is not enough. As I read, what the plaintiffs and the town are asking you to do is actually to lower the bar and to change that rule because of the passage of time.
But aren't we? We're looking at intent here, correct?
Yes, we are.
Why isn't the bankruptcy proceedings the best evidence of intent we could possibly have? The fact that the bankruptcy was closed out by the transfer back of these parks and avenues for virtually no consideration because they had no value, because they were parks and avenues. Why isn't that the best evidence?
2 responses. First of all, there's evidence in the record that there was a boom and bust cycle in Martha's Vineyard in Oak Bluffs. In other words, in the early 1870s, land was very valuable and it was selling. By the time Mr. Luce went bankrupt, there was a bust.
What's the date on which the trustee sold these?
I believe it's 1876.
Okay. So
Thereabouts.
we're still in the 1870s.
Right, but and I cited it in my second brief. The historical record indicates that at that point there was a bust in the
That may be, but I think, as I understood, at least Mr. Rappaport's point was not should the trustee have, had sold this for $5 or 10 or 15 or 20, but compared to a buildable lot, So what you're doing is comparing buildable lot versus non-buildable lot. And then it doesn't matter whether it's a boom or bust, correct?
Perhaps not, but let me point out something else in the record
Sure.
that's important. One of the deeds in the record sells 13 lots for $1. 13 buildable lots for $1 and quote-unquote other consideration. We don't know what that is. I think to get at the economic analysis.
Was that back to a family person?
I don't believe so.
No.
I believe it was a bona fide
Third
sale.
party, yeah.
Now, part of the problem here is this economic argument was raised by the town for the first time to this court. It really wasn't raised to the land court, wasn't raised to the appeals court.
Well,
No, it's part of
the
the
record.
It is.
I mean, it seems to me when you look at, even with, are we in a boom cycle or a bust cycle? You look at the size of these things. They are, each one of them is significantly larger than any of the lots, and combined, they're huge compared to even a large number of the lots.
Well,
$5?
Except that, again, I have a deed of 13 lots for $1.
Had no taxes been paid on those 13 lots?
Had no taxes been paid.
Were they subject to a tax, a levy? Do we know?
We don't. The record is murky on taxation. I guess the only point I wanted to make about raising this issue at this late date is that the economic analysis would be a lot more probative if all the deeds had come into evidence and we had done a real thorough study. No one did because the issue wasn't raised below. And I think at this point, to take an inference that the grantor intended there to be parks because of that price goes too far.
Could you address the issue that's been drawn to our attention this morning, that there are deeds referencing different setback requirements if the lot bordered on one of the parks?
Again, that's another issue that was never raised in any of the briefs. This is actually the first time I've heard this argument raised. I would have to look at the deeds and see if that's really correct. Again, this is the first time this has come up. So I think what you're dealing with in this case, this is a very all-encompassing easement. The plaintiffs are not just asking for the right to walk through the property, they're asking for the right to use every inch of it and prevent the defendants from doing anything with it. And really, all they have to support grantor intent is the plan itself.
Could I ask you, the advertisement does not make specific reference to parks, but it does have its flowery little quote referencing wooded paths. Where are the wooded paths if these things are buildable lots?
Well, first of all, the wooded paths could be within the lots themselves.
They're pretty small for wooded paths.
Well, I think this is important to point out. You're assuming that each buyer just bought a 50 by 100 a 5,000 square foot lot. The record that we've put in demonstrates the contrary. People bought large aggregations of these lots. And in fact, the lots today, the parcels are, these so-called park parcels are no bigger than the average lot size in this area.
Well, that turns out to be the way people bought them, but the way they were put out on the plan, which is what was there at the time this advertisement goes out, the plan suggests lots of, little buildable lots, and that suggests they're going to be sold individually, and yet that there would be, quote, wooded paths. I look at this and I don't see anything where you could possibly have wooded paths if the parks aren't parks.
Well, for example, you could have wooded paths along some of the streets that border the Crystal Lake. It's not clear from this plan, for example, that Marginal Street, which borders Crystal Lake, is not itself a wooded path. But here's my problem with this way of looking at this. We're speculating now on what the grantor might have meant by the word woodless path, which, by the way, wasn't even his own words. He was quoting a poet who wrote a poem about woodless paths. So he's incorporating by reference a poet.
Right.
And so 130 years later, we're trying to say, well, that must have meant easements in these parks.
That combined with all of the words used on the plan, the irregular shape and size, the other features.
Well, in my view, if this grantor had intended to give private easements to these parks, he would have done exactly what the grantors in Abbott did, which is they had advertisements all over town saying, buy a lot in this subdivision and you get the right to use these beautiful parks that we're going to create. If that was the grantor's intent, Why didn't he say that in the
Because
advertisement?
what he said in the advertisement is the lithographic plans and any desired information is there. I mean, there's lots of other wordiness. I mean, the high moral character of the residents, I think, is beyond dispute.
I would hope so.
I mean, and I understand your problem. Your problem is we've never said the plan alone, and so we look to other kinds of things.
It's a little bit more than just that you've never said the plan alone. It's that if you look carefully at the cases where you have found an implied easement of the nature we have here, you have one of three things, or a combination. One is you have statements by the grantor inducing people to buy in reliance upon a promise that there would be parks. Or two, you have actual contemporaneous use of the parcels as parks. Or three, you have a showing of necessity, that is, that these parks provide access to waterfront, which you otherwise couldn't have, or some special amenity that makes it a focal point for the neighborhood. We have none of those things in this case, and I just want to clear up one thing in the record. The record affirmatively demonstrates the lack of use of these parks for the first 40 years from when the subdivision was created.
But isn't that in part because we don't have anybody who was alive and could testify to that? In other words, open land, I mean, what you do have, as I assume, is a factual finding by the land court judge that there's some evidence that's been used by members of the public for bird watching and other occasional activities. I mean, here, given that the town is saying this is not public land, so essentially what you have to do is to show, which is very difficult, I mean, because we're now so far away, unless it's in writing, I don't think there's likely to be anybody who was old enough to know what was happening.
Well, surprisingly, there is in this case.
Oh, there's one person.
There's an affiant named Louise Pierce who says she moved into the neighborhood in 1910.
Right.
And in 1910, there was just one house in this whole subdivision.
Yeah, one of the reasons we don't have evidence about how it was used is people bought the lots
afterwards,
but didn't
do anything.
They bought them, but they didn't develop them until many, many years later.
That's correct.
Okay, but could I also ask you, going back to the bankruptcy trustee, what got deeded to Ichabod Luce made some reference to all of the lots already having been sold?
It did say something about that this is what remains after the lots have been sold. I'm not sure it said all of the lots. And again, we haven't done a complete title search, so it's possible that there were still some lots that were also transferred to the bankruptcy trustee. We just don't know on this record.
Is this a case we could decide on the burden of proof? The burden of proof rests with the plaintiffs, and this is just the way we're going at this morning. It's kind of evenly balanced, in which case they lose.
Well, Justice Green, I agree. The absence of evidence weighs against the party with the burden of proof. I don't really think this is 50-50, because I think the most important element of proof here that's missing is the express words of the grantor. If these rights were so important,
when you said express words of the grantor, you're talking about it can be written words, correct? The difficulty is if you look at the description and the plan, it would be one thing if there was just vacant, if there was this parcel. And what's odd about this plan, it's not as if you suddenly bump up against Crystal Lake. I mean, there's a distinct attempt to make not tiny little lots, and it gets called a plaza or a park. I mean, and if the grantor is saying, go look at this plan, why would I not assume that that's a park?
Two responses. First of all, just to be clear, the ad we're talking about, which references a plan,
yes,
there's nothing in the record to indicate that it means this plan. So that's an important point.
What do you mean there's nothing in the record that it means this plan?
The ad doesn't say, look at the plan dated 1872 by these surveyors.
Is there any other plan that we're aware of in this?
Well, actually, there is in the record another plan prepared by the same surveyors a few years later that doesn't show three of the lots as parks. It shows one of them, the plaza, and not the other three.
But that's 3 years after the ad went out?
Well, I can check the date. I'm not sure. But here's my other point in answer to Chief Justice Marshall's question. The grantor may have intended, and I think this is probably the most logical inference one can draw, to dedicate these parks to the public at some point after the subdivision was done.
Or if not to the public, to the people in that subdivision.
If he had intended to give private rights, this is in 1872, 7 years after the court decided the Light case, which says you can't create enforceable rights on the basis of a plan alone. If that was his intent, I think the logical conclusion is he would have put it in writing. And this kind of gets to the final point I'd like to make today, he would have created some structure, like a homeowners association, to administer and oversee these parks, so-called parks. And that brings me to the final point I'd like to make, which is there's some implications here that need to be considered, very practical ones. There are hundreds of people who potentially are homeowners in this subdivision. The law of easements is that all the easement holders are jointly and severally liable for the maintenance and for tort liability if something happens. Most of the people who own property in a subdivision, they're not parties to this lawsuit. But if you recognize an easement in their favor, you're also imposing an obligation upon them to pay their pro rata share. And you're doing that without any notice to them in the record, without them even being parties. All of a sudden, they have not only the burdens, not only the benefits of this easement, but the burdens. And I submit that's an extraordinary thing to impose upon people who aren't even parties.
Is there anything in the record that suggests that your clients had ever put up any notices that said, private land, keep off?
No, and the reason, in all fairness, is they didn't know they owned this land, and Mr. Rappaport's correct about that. It all came about because the tax taking triggered a title exam, and it got traced to them. So,
but even since then?
Since then, no, they haven't posted it. They haven't posted it. They haven't.
Any hunting signs? No hunting?
I'm not aware of any hunting signs.
There are a lot of deer on Martha's Vineyard.
Yeah, there may well be. I thought, no, they haven't taken those actions. A second intensely practical implication that needs to be considered, what happens if these hundreds of people have disagreements over how these lots are supposed to be used? One of them is called a plaza.
How is that different from what happened in Abbott?
Well, to be honest with you, I think the Abbott court recognized that problem and sidestepped it.
Well, they recognized the problem and said it's not a reason not to recognize an easement?
Well, I would differ with that conclusion. I think that what this will breed, if you create this easement held by 250 people jointly with no standards to guide what's supposed to be done in this land, it's simply going to be more litigation without any way of really resolving it. Again, what if the bird watching people want the land?
There hasn't been litigation for 100 years.
I'm sorry?
There hasn't been litigation for 100 years.
Well, it will be now because everyone is now aware of this, and there could be...
Were there waves of litigation in the time that has passed since Abbott?
Well, I don't know the current status of...
I mean, did those people who found that, that they had an easement start suing each other over whether we're going to use it for bird watching or build a baseball diamond?
No, but here's the difference. The parks that we're talking about in Abbott were very well established, and I put photographs in the record of them. It was clear what the contemporaneous use was. One of them looks like the Boston Common. If you look at the photo, it's clear. These parcels are really overgrown woodlots. And what did the original grantor intend for them? And how do you sort out competing claims about whether they should be used for bird watching or should be cleared for strollers? There's just no evidence from the grantor, no standard upon which anyone can judge that.
One reason, I suspect, is because the grantor went bankrupt before he had time to develop it.
I think he went bankrupt, that's correct.
Mr. Kimmel, can I ask you this, and it may be totally irrelevant, what's the status of the counterclaims here?
They have been dismissed without prejudice.
So, so we're only left with the original complaint?
That's correct. Okay. The only thing
and the agreed statement?
That's correct.
Okay. Thank you.
Thank you very much.